Today, I'm very excited to announce that I had my first oral argument before the Ninth Circuit Court of Appeals. May it please the court, my name is Andrew Newcomb, counsel for the petitioner. It was a very interesting issue that was on appeal regarding the Board of Immigration Appeals Authority to deny a motion to reopen. The critical thing that was at issue with the case today was that the board applied a standard requiring a heavy burden on the movement to establish a likely different result with previously unavailable evidence. Now that standard, which is from the original case matter of Coelho, was later contextualized and nuanced a little bit by the matter of LOG. To distinguish from matter of Coelho, matter of LOG, in that case the movement had not had an opportunity to fully litigate their case on the merits at the prior hearing. And because they had never had a chance to fully litigate their hearing, the board held that they would have a lower standard in terms of only showing a mere reasonable probability of success on the merits. And this is in stark contrast to the heavy burden of showing a likely changed result, because in the case of Coelho, that respondent did have an opportunity to fully present their case, and thus they should be held to a higher standard. That was the gist of what we were discussing today. Among the other points that came up were whether or not the board should consider the entirety of the record of the previous proceeding or only the evidence attached to it. And we saw a split among a lot of the different circuits and within the United States. The 8th Circuit and the 3rd Circuit and the 6th Circuit in their decisions all clearly distinguished the Coelho standard from the LOG standard. However, the government argued today that there's only one standard that governs and that they're not distinguishable. The panel at the Ninth Circuit seemed to be not very persuaded by the government's view, considering that different circuits had distinguished those two cases as articulating entirely different standards for review. Pressed the government attorney to really kind of explain, if immigration law is supposed to be uniform throughout the land, why is it that some circuits are dividing it and others aren't? And essentially the government was not willing to budge on that opinion. Finally, they were asked by the panel, even if what you're saying is true, that our client in this case didn't even submit enough evidence to satisfy that lower standard. If it is the case that the board incorrectly applied the standards and incorrectly articulated the distinction as a matter of law, shouldn't we remand anyway so that the board can at least apply the correct standard? And to that, the government didn't really have much of a rebuttal. They just said, and I'm quoting, I guess it wouldn't be the worst thing in the world, Your Honors. So hopefully, this is going to be a good result. It's going to help a lot of families in the future reopen their cases where they have new eligibility for relief. For example, if they're applying for 42B, cancellation of removal, and at their prior hearing, they did not have a child, but now on appeal, they do have a child, creating a whole new basis for hardship towards that child. And it can help a lot of families have another shot at gaining lawful permanent resident status instead of having to live in the United States with an order of removal or with no status.